We'll move on to item 3, which is communication. Item 3.1 is the update to the addition of disciplinary accommodation language to San Joaquin County job announcement.
Thank you, Chairman. The Commission recalls last month we presented some research related to job accommodations, the Americans with Disabilities Act, job descriptions, and job announcement. Amy Brimmer, our classification analyst, is going to report back to you the actual recommendations from that research for the Commission's consideration.
Good evening, Chairman and Commissioners. Amy Brimmer. Again, this is an informational item carried out from the August 12th and subsequent September 9th meeting under your direction to come back with an action item regarding the inclusion of physical and mental requirements in the class specifications, and then how they relate to then their content in the job announcements that the county publishes for prospective employees. So while we have had those physical and mental requirements on the job announcements, we had not at any point published anything that would indicate that they are considered in compliance, or that we would be as an employer in compliance with the Americans with Disabilities Act to provide an accommodation as needed. So based on a combination of the input this commission has contributed along with the data accommodations to enable individuals with disabilities to perform essential functions of the job to which they are applying. If you haven't already, you may wish to turn to page 3 of 9 in the sample job announcement. It's attached to this agenda item, and the ADA language immediately follows the physical and mental requirements and our equal opportunity employer statement. So in addition to what is also provided in written communication for the agenda item, we're prepared to entertain any questions or concerns you may have at this time.
Any questions from the commission?
No, I have no questions. I would like us to approve your recommendation. Is this an action item, or is it just information?
I'm sorry, clarify, it's informational only.
It's informational only, and absent any questions from the Commission, we will implement the recommendation that we brought forward into the discussion with you for the last 2 months. The job announcements do not require civil service approval in the same way that a job specification would. Clarification. Thank you.
Well, thank you for your report tonight and your follow-up to the issue that I think you brought before the commission 3 months ago. So thank you very much, Jack.
Thank you.
Agreed.
Okay, item 4, old business, and there is none. Item 5, new business. Is there amendment of class specifications? A, there are none. B, the adoption of class specifications, there are none. C, classification studies, none. D, staff reports, none. And E, request for appeal hearing, under Rule 3, classification, there are none. Number 2, under Rule 18, dismissal, suspension, demotion, or reduction to stay, there are none. Under number 3, Rule 19, which is a violation of rules, request for appeal, there are none. And number 4, Rule 20, discrimination, request for appeal, and we have 1A, Elizabeth DeYoung.
So Commissioners, before we open this item and I read the opening statement to explain the item tonight, I do need to confirm that if Elizabeth DeYoung, Ms. DeYoung, are you on the telephone call tonight? Ms. Strange, do we have any pop-ups in either the email that was provided or any other link? I just want to confirm before we open the item. Public comment? Okay, before we open the item, I wanted to make sure that she was not present over the telephone. Chairman and members of the commission, the item that's before you is a Rule 20 request for an appeal hearing filed by Elizabeth Dale. The sole issue before you this evening is whether or not to set this matter for a hearing under Rule 20. The commission has discretion regarding whether or not to hold an appeal hearing. The commission is not required to hold a hearing on a Rule 20 appeal. As commissioners, you've been provided a copy of the appeal request form completed by the appellant and a post-investigation summary report prepared by the Eeo Office. The appellant will be provided an opportunity to state why the appellant believes that the Rule 20 was violated and why the commission should grant the appeal hearing. The county Eeo program manager, Mr. Roland Davis, is present and will provide the commission with a summary of the complaint, the investigation of the complaint, and a brief overview of why the county Eeo Office determined that a violation of Rule 20 did or did not occur. The commission may ask either the Eeo Office or the appellant clarifying questions. This is not a forum to hear the merits of the appeal, but it is a forum to determine whether there are sufficient reasons for the commission to re-examine the facts of the complaint and the determination of the Eeo Office. If the commission determines that the complaint was adequately investigated and addressed by the Eeo Office, and that a full hearing by the commission would be unlikely to change the finding of the Eeo Office, I would recommend that no hearing be granted. If, on the other hand, the commission determines that the complaint was not adequately investigated or addressed by the Eeo Office and/or the investigation findings were not supported by the evidence, I recommend that you set the matter for hearing. We would first hear from Ms. DeYoung, so I just want to confirm once more that she is not on the telephone. Do we have any in the meeting?
We have nothing in email.
Okay. It is in a COVID world, I want to make sure we provide her the opportunity. Okay. Without Ms. DeYoung being present, we will ask Mr. Davis to come up and share what he has prepared regarding the investigation.
Good evening, Chair, Cerna, Commissioners. My name is Roland Davis, the county's EEO Program Manager. I'm here this evening to provide a general summary of the steps taken by the EEO Office pertaining to the formal Civil Rule 20 discrimination complaint filed by Ms. Elizabeth DeYoung against Ms. Tori Berber-Salazar. At the time of the events giving rise to the Rule 20 complaint, Ms. DeYoung was employed as a Deputy District Attorney, and Ms. Berber-Salazar is the San Joaquin County's District Attorney. I would like to take the opportunity to reaffirm when processing the Rule 20 complaints, the EEO Office is a neutral, unbiased, third party. The EEO Office does not represent the complainant, the respondent, or the department. The county's EEO Office facilitated an impartial, thorough investigation, reviewed the key elements of Ms. DeYoung's complaint, and provided factual findings to determine whether there was a violation of the Civil Service Rule 20 complaint. As indicated in the summary provided to you, Ms. DeYoung's formal Rule 20 complaint of discrimination on the basis of race, Ms. DeYoung alleged Ms. Berber-Salazar made a comment that was racially motivated, which caused a hostile work environment. Ms. DeYoung, a white female, alleged that the comments made by Tori Berber-Salazar were a form of reverse discrimination towards white individuals. While the Commission was provided a copy of the investigative report summary prior to this evening's meeting, I will endeavor to provide highlights regarding the investigation findings that the EEO Office believes are pertaining for your consideration regarding Ms. DeYoung's request for an appeal hearing. First, I would like to start with the background of the situation. In January 2020, eighth grade students from Ripon City Schools attended the Choices and Consequences program. The program is a collaboration between the County Office and the County Office of Education and the county courts that offers a program to middle school students related to the consequences of drugs and alcohol use. During these events, County Superior Court Judge Richard Villanos and others speak in person to the students and at their school. And then the group video conference with inmates of Folsom State Prison and the Central California Women's Facility in Chowchilla about the consequences of inmates' actions. Ms. DeYoung's daughter attended this event. However, Ms. DeYoung was not given an advance notice of her child's participation in the program, and the school district did not obtain her permission for her daughter to participate. Ms. DeYoung heard about the program after the fact, and her daughter informed her that the inmates appeared via a two-way video stream wherein the students could see and interact with the inmates and vice versa. Due to Ms. DeYoung's prior work as a DA at Stanislaus County, where she appeared multiple times at murder hearings for 4 offenders, she was concerned those murder hearings would connect her daughter to the offenders and provide a name during the event. DeYoung's biggest concern was that the school did not provide the parents with information before the event, which would have allowed her to discuss the event with her daughter in advance and determine whether she was comfortable having her daughter participate, given the circumstances. When Ms. DeYoung spoke to the principal about the concerns, the principal ultimately directed her to Ms. Berber Salazar, who, according to the principal, organized the event. As a side note, Ms. Berber Salazar did not personally organize this event, but her office did help coordinate the program and authorize representatives from the office to participate. Based upon her conversation with the school principal, Ms. DeYoung requested to speak to Ms. Berber Salazar regarding the program. Initially, Ms. DeYoung presented the issue as a concern raised by the parents whose children attended the program without parental permission. However, it quickly became clear that Ms. DeYoung's concern was more personal in nature than the representative of a parental group. So now I'd like to give you an overview of the actual investigation. The investigation was conducted by Megan Donahue, an attorney with the law firm Shaw Law Group. The investigator is an independent investigator who was assigned to conduct a neutral, objective investigation into the allegations made by Ms. DeYoung. The investigation process included the following: personal interviews by the investigator with the complainant and the respondent, interview statements with 4 witnesses, 2 of which were requested or offered by Ms. DeYoung, and a thorough review of Ms. DeYoung's allegations. There was only one allegation to be investigated, which was whether or not on January 22nd, 2020, during Ms. DeYoung's conversation with Ms. Berber Salazar about the program, Ms. Berber Salazar made several racial, ethnic-based comments during the conversation with Ms. DeYoung that she found offensive and negative toward white people in Ripon. Specifically, Ms. DeYoung alleged that Ms. Berber Salazar made the following comments: do white Riponites need permission slips to see African Americans and Hispanic inmates? White people in Ripon need to gain perspective of veteran inmates, those who have served their time. And last, a particular white Riponite who caused Berber Salazar problems in the past was after her. At the conclusion of the investigation, the investigator found that Ms. Berber Salazar asked the following question of Ms. DeYoung during the January 22nd, 2020 conversation: are the parents upset because the inmates are Black and Hispanic, or are they upset because they are convicted murderers? Ms. Berber Salazar acknowledged that she said as much during the conversation because she was attempting to get a better understanding of why people were upset. However, the investigator also found that Ms. Berber Salazar did not make the other comments attributed to her by Ms. DeYoung. The investigator's findings were based on a corroboration of witnesses who heard Ms. Berber Salazar's side of the conversation. The investigator is responsible for assessing the credibility of the witnesses and found that the witnesses were credible. The witnesses stated that Ms. DeYoung was very upset at the start of the conversation and that it was hard to understand the issue because Ms. DeYoung was not communicating clearly. Ms. Berber Salazar asked the question to determine which program was at issue, what concerns the parents had, and how best to address the concerns. The witness recalled that Ms. Berber Salazar asked Ms. DeYoung whether she was upset because the students spoke with the inmates or because the inmates were Hispanic and African American. While they discussed whether the parents should have signed a permission slip allowing the students to attend the program, this witness told the investigator that Ms. Berber Salazar never asked Ms. DeYoung was white Ribbonites need permission slips to speak to Hispanic or African American people. According to this witness, Ms. Berber Salazar never used the term white people or white Ribbonites. During the conversation with Ms. DeYoung, the witness shared that the investigator that she resides in Ripon and that Ms. Berber Salazar has used the term Ribbonite in the past. However, she would have recalled if Berber Salazar had used the term white Ribbonite. On the contrary, the witness identified by Ms. DeYoung did not hear either side of the conversation between Ms. DeYoung and Ms. Berber Salazar. The witness could only repeat what Ms. DeYoung told them about the conversation and corroborate that Ms. DeYoung was upset after the conversation. However, their accounts to the investigator did not speak to the issue of what occurred in the January 2020 conversation between Ms. DeYoung and Ms. Berber Salazar. As the EEO program manager, it is my responsibility to review each investigative report to determine if it is thorough, accurate, and whether the evidence obtained during the investigation supports the findings of the fact. In this instance, I found that each element were met. I am also responsible for determining whether the investigator's findings support a violation of Rule 20. In this case, I found that Ms. Berber Salazar's question about the racial identity of the inmates was not a violation of Rule 20, which prohibits discrimination. In Ms. DeYoung's appeal, she provides no specifics regarding the basis for her appeal. She simply disagrees with the outcome of the report. If the outcome of the report is supported by the preponderance of the evidence, the appeal should be denied. Additionally, the remedy that Ms. DeYoung seeks on appeal, financial compensation, and a formal apology, which is outside the Commission's authority to grant and not supported by the outcome of the investigation into her allegations. Lastly, Ms. DeYoung is not without recourse. She is free to file a DFDH or EEOC complaint with the respective agency who investigates complaints of discrimination on the state and federal level. These agencies are more suited to assist Ms. DeYoung in obtaining the remedies that she is seeking. Therefore, the EEO Office respectfully requests that the Commission deny Ms. DeYoung's request for an appeal hearing for the aforementioned reasons. Should you have any questions, I will be happy to address them. Thank you.
All right, so let's take this in pieces. Before I ask the Commission to weigh in, I just have some kind of procedural questions. So, was Ms. DeYoung, was she going to take her appeal to teleconference, or
She
how do you
was,
understand that?
she was noted that she could appear this evening. It was her choice whether she appeared in person. We made sure we had room for this particular item, or appeared telephonically.
And did she acknowledge that she would be coming, did she acknowledge she was going in, or?
Mr. Davis?
It's unclear if Ms. DeYoung actually acknowledged she was notified, and she was sent certified mail, and there was a confirmation on the certified mail, but we didn't get any confirmation from Ms. DeYoung that she would actually attend the meeting.
So she was informed through certified mail, return receipt, I'm assuming.
Yes.
You were notified that she had received it, but she never acknowledged whether she would be attending. I'm concerned that she gets the opportunity to state her case, but if she's not here, then they weigh on, at least for me, the decision on how to move forward. So I just want to make sure.
The standard practice, as I understand it, and Mr. Davis will jump in if I misstated, is that we notify them by certified mail.
Okay.
This is what the commission's been familiar with in the past, and it's up to the appellant whether he or she appears or does not appear.
That is correct, Sheriff Steiner. We do notify them by mail and certified mail, and we leave it up to the actual complainant to confirm if they are going to attend the meeting or not.
And then the next somewhat procedural question, I guess, process question is, and in this, I would suggest in the future, it was hard to read the copy. It came out kind of dark. So it was, I would suggest somehow to get a cleaner copy would be easier, at least for an old guy to read. So my question, maybe this is for counsel, she's filing a discrimination on the basis of race. And she's Caucasian. Is that covered on the act?
Well, she's alleging reverse discrimination.
I don't recall the act addressing reverse discrimination.
Well, if you say something is on the basis of race, and the race in the act doesn't specify the different races. So white is a race. If you're treating somebody differently because of their self-identified race.
Well, I'll give an example that kind of illustrates how that is. When you apply for a job, and you often are asked to mark the box on race, there are various categories.
Right, but that is for statistical compilation purposes, not to anything to do with the application that you're making.
Okay. I just want to make sure that she's protected under the act. I mean, I can see female, age, whatever, but.
If I understand her, Mr. Chairman, if I understand her allegation correctly, she's asserting that the district attorney has a bias against people from Ripon based on their cultural
Right. I understand that assertion, but I'm just, now let me, and now we turn to what the commission asked. Is she a county employee?
She was a former county employee. She actually resigned soon after this case.
Was she a county employee at the time of the incident?
She was not.
So
She
did she
filed
have access to Row 20?
She was.
She was, but she filed the complaint after she.
Oh, that was my question, yes. When the
A little bit of background that might round the edges on this is that she had been a district attorney, deputy district attorney in Stanislaus County,
Okay,
and then relocated to San Joaquin County.
okay,
This program apparently involved inmates who had been prosecuted in Stanislaus County. So her concern for her daughter was that some of these inmates might have been people that she had prosecuted, and she was concerned that her daughter, in interacting with these inmates in the two-way video, her name would come up and they would somehow make the link between the daughter's mother as a former prosecutor in Stanislaus County. That was the source of her
okay.
concern, as I understand it. then she went to work in her office here, went down the hall to make her complaint to her boss, the district attorney, was unsatisfied, was offended by the district attorney's verbiage, and submitted her resignation. I believe that's the chronology.
Gotcha. Okay, that helps me understand. I'm gonna ask some more questions later, but I'll let
Sure,
the commission.
Sarah, before the commission asks the remainder of the question, we do have the certified receipt, and it appears to be her signature.
Okay, thank you.
What's the date of that?
10/14.
So a month,
October 14th.
and it let her know that it would be tonight.
Yes.
So a month's notice, basically,
Okay,
almost.
I'll entertain any questions from the commissioner.
Yeah, this is for the record, Commissioner Gutierrez. Yeah, I'm glad that was one of my questions. How do we know that she received the notification? So she signed the letter. The report, the attorney that did the investigation, concludes that the allegation is substantiated. Correct?
That's correct.
Okay, the allegation that the district attorney made certain statements,
Right.
that those were substantiated.
What was substantiated in the report was saying that the district attorney did ask for clarification if these people were offended. That's what she asked, if who was offended, or was it people who are Hispanic and African American? She asked for clarification. The report substantiated that. That's what substantiated. However, we did not find that that was a violation of Rule 20. It was just a matter of clarification. It wasn't an offensive comment.
Okay, that's what I wanted to get clarify that. Your investigation is that there wasn't a violation of the rule.
That's correct. Yes, Commissioner Gutierrez.
Okay.
Thank you, Commissioner Gutierrez. Any other questions from the commission?
Yeah, I have one. Mr. Davis, there's it appears that there was a second conversation after this one, where the district attorney reapproached, Ms. DeYoung. Is that accurate? Because she said in her statement that then some off-the-cuff conversations, off-the-cuff comments were made by the district attorney. Was that a second conversation that occurred?
Yeah.
And if it was a second conversation, did the investigator address that conversation to determine if there was anything inappropriate?
So, Commissioner Bocconi, you have the summary report. You do not have the full report. The summary report, there was a situation where the district attorney went back to Ms. DeYoung to make sure she was okay, because she seemed like she was upset, and had a conversation with her. That was the basis of the second actual conversation. It was nothing more than just trying to find out if she was okay.
Thank you.
Any other questions from the commission?
Yeah, I know this seems straightforward to me, and I don't know if I'm ready to move forward.
So, Chair Stern, as a reminder tonight, the
Sure.
commission is to determine whether to accept it or reject it. Or to grant the appeal or deny the appeal.
So the charge of the commission is to either grant Ms. DeYoung an appeal hearing or deny the request for an appeal hearing. I just had a couple more questions. This was not a county-sponsored activity, as I understand. Is that correct?
This was, no, this was something that the district attorney's office was participating in, but it was not a county-sponsored event.
It was an event sponsored by a school district.
That's correct.
And then I want to make sure I understood what her remedy request was.
The remedy request was, financial compensation and an apology from the district attorney.
Of which the commission has no authority to grant.
That's
To
correct.
grant financial settlement.
That's exactly right.
And I think you may have mentioned it, counsel, but she's no longer a deputy DA with the county, is that correct?
I think she resigned over this incident, and that second conversation, as I understand it, took place when the district attorney was handed her resignation.
Okay. Thank you. I don't have more questions. What's the pleasure of the commission?
I'm ready to,
Just a second, please, sorry. Our county council, if I may, Henry, unless you can hear me, our county council, Mark Files, would like to make a statement.
Okay.
Thank you, Mr. Miles.
Thank you. Good evening. I'll keep this brief. You already heard Mr. Davis' report. You have been told that if the complaint was adequately investigated and addressed, but nobody uses this, they can't hear me. You've been told that if the complaint was adequately investigated and addressed by the EEO office, that you should not grant the appeal. You've been provided with information setting forth the investigator's evaluation of the allegations and the testimony of the three people with direct knowledge of the conversation, resulting in a conclusion that while the race of the inmates was more than likely discussed, it also revealed the absence of evidence to support the allegation of the other statements that Mr. Young claims that the district attorney made. Rule 20 is intended to prevent discrimination in the workplace and to provide a means of redress should that discrimination occur, and that is a rule and philosophy that the county fully supports. However, Rule 20 is not intended to prevent relevant questions of race from occurring within the workplace. Because this matter was appropriately investigated by an independent investigator, because it was appropriately addressed by the EEO office, and because the remedy sought is beyond the authority of the commission and is not supported by the findings, the county believes that you should deny the request for the appeal. Thank you.
Are there any others?
I'll just say one more thing. Mr. Miles, you clarified exactly what's been said now, I think, 3 times to us, that, I'm not asking you a question.
Oh.
So, but, you know, the question coming down, was it adequately investigated? Would there be any difference if we had an appeal? That's what I'm focused on. And I know you all are too, I just felt compelled to say something.
Are there any other persons in the audience that can speak on this matter? Okay.
To my knowledge, no.
So again, just to restate, the commission is tasked with either 1, approving her request for appeal hearing, or 2, denying her request for appeal. So I'll take the pleasure of the commission.
I move that we accept the recommendation of the EEO office and deny the request for appeal.
We have a second?
I second.
Any further comments? All those in favor say aye.
Aye.
All those opposed, there are none. The appeal is denied.
Thank you.
All right, under F, other requests, there are none. Item 6, set dates for appeal hearing for the Count Book 3, the Probation Department, classification project number 19-003.
So, Commissioner Serna and Commissioners, under Rule 3, or classification rules, the appointing authority or the incumbent may appeal such allocation in writing to the Civil Service Commission not later than its next regularly scheduled meeting following the date of the allocation at the time that the commission set an appealing for the year. So you heard a classification study at the last meeting, and the employee is appealing to you. So what we're requesting that you do tonight is set a date to hear that hearing. We do have a list of the dates on the agenda for your review.
So this is on a regular scheduled meeting date?
Correct.
Okay, all right. So, I have a conflict and won't be at the December 9th meeting, and just letting you know.
Thank you.
Yeah.
So what's the pleasure of the commission in terms of setting the date for the appeal?
How soon do we have to set it? For the next, does it have to be the next regular scheduled meeting?
I don't think there's a hard, fast rule set it when you have a quorum available.
I recommend January 13th, 2021.
Is that good for everyone else?
Yes.
Mr. Gutierrez, are you okay with that?
Let me just look at my calendar, I want to make sure.
I think that's my last commission meeting.
That works out.
Oh.
That's, January
13th.
13th. Yeah, I'm okay with that.
Okay, so let's set January 13th for the hearing, of classification study number 19-003, the probation department.
Thank you.
Okay, under item 7, public comments, is there anyone from the audience who'd like to?
We have two different versions of public comment tonight.
Okay,
The first one is persons wishing to address the Civil Service Commission are asked to limit their total presentation to a maximum of 5 minutes for each side of the issue for individuals who may be in-house. So if there's anybody who has public comment in-house, please come forward. In our virtual world, our second version of public comment is via telephonic or email. So if public comments are limited to 250 words or less, and may be submitted by emailing sjccs.publiccomment@sj.gov.org, and every effort will be made to read all the comments received into the record. Some may not be read due to time limitations. Comments received after an agenda item will be part of the official record on file with the commission if received prior to the end of the meeting. Is there anybody telephonically who would like to address the commission? Ms. Strange, do we have any through our email?
No email.
We do not have any public comment this evening.
okay, so there's no any comments either from, folks in the audience and or, the second. Okay, item 8, our future meetings. The next meeting of the commission will be December 9th, 2020, and in this building here. Item 9, our appeal hearing, there are none. Item 10, closed session.